I call the whistle.
Yeah, I've been dying to take a call all morning, so I appreciate this opportunity to contribute to part two. And I also want to focus on the validation provision in section 170, and I do thank the Minister for the clarification, because essentially there was some requirements under section 123 subsection 7 of the RMA Act, that refers to a 60 working day notification period after public notification for submissions to have been received. The question that I have actually is about the period between the 14th of January to the 28th of February 2014, and how many of the 9,400 submissions does that period actually apply to? And it's actually relevant. And I haven't had clarification about access to this process of the hearings panel. So essentially Auckland Council went out and they, as I said before, got over 9,400 submissions to the development of the Auckland Unitary Plan. They also had an extended period where they got another 3,800 submissions. They then wrote the Auckland Unitary Plan. And that plan was given to the hearings panel to then consult. And this is my question for the Minister, presumably only with people who had made a previous submission. And that's where this validation clause actually becomes relevant. And so my colleague, the Honourable Phil Goff, said that there were 5,000 submissions to be heard by this hearing panel, and they're a subset of the total 13,200 submissions. So in fact, this validation clause is incredibly important if that's the relevance of this validation process. So I need to know from the Minister whether or not the qualification to contribute to the hearing panel process is actually only based on you making an original submission to the Auckland Council Unitary Plan process. And so the qualification of, what is a submission becomes incredibly important actually to the integrity of this whole piece of legislation. So if the Minister could confirm that, that would be good, because I guess in looking at this particular clause, you want to make sure that the clause actually has a purpose. So does this validation clause actually matter? And I think that the Minister should let the public know the purpose, the rationale, the relevance of this particular clause, because if it does then determine qualification for those submitters through participation in the process from the beginning to be heard, then actually that's really, really important. If it doesn't, and if it doesn't matter, and actually then I think the integrity of Part 1 comes into question when in fact under, and I'll just reference this section 144 subsection 5, that actually the hearing panel ultimately will make recommendations that actually may be outside of the scope of the submissions that they receive. So there's not actually going to be a relationship between the submissions that they received, where the cut-off date was the 28th of February 2014, and then the ability of those submitters to make a contribution to the hearing panel process. And that's actually the crux of the argument, and it is a serious point to be discussed, because what we know through other parts of this particular legislation in Part 1, and I hope I seek your indulgence, Mr Chair, just to reference back, but under section 144 subsection 8, 9b, or 8, that the panel can identify any recommendations that are beyond the scope of the submissions made in respect of that topic or topics, and also 9b, that any other matter that the hearing panel considers relevant to the proposed plan that arises from the submissions, but then they've got these two words, or otherwise. And so or otherwise actually means that they stand apart or outside of the process. And in fact, that's what we are concerned about in terms of the integrity of this process. Because, Mr Chair, what that essentially says, based on what I've just read, is that this Auckland Unitary Plan Independent Hearings Panel can actually introduce a whole lot of material and make recommendations to the Council that have got no rational basis in terms of the process that we've been through. So, Auckland, Mr Chair.
Call Ron Mark.